All right, let's go ahead and get started so Jennifer has tons of time to talk about this very important topic. Thank you all for joining us today for our next installment in our Countdown to NTI webinar series. Jennifer, if you don't mind sharing those slides, please.
Do you see them?
Yes,
Great.
they are in presenter mode.
Of course they are.
So we can just go ahead and get started, Jennifer, if you want, and you can kind of fiddle around with it. That might work. There we go. Perfect. It's a Wednesday afternoon. All of our computers are probably a little slow by now. So welcome to, like I said, our next installment in our webinar series, Strategies to Disarm Domestic Violence Offenders. Next slide, please. I'm Katie Mascalunas. I'm with the National Center for Victims of Crime. So a couple of housekeeping things, and then we'll get into Jennifer's great presentation. This webinar is being recorded. If you signed up for the webinar, you'll be sent a recording afterwards. As well as Jennifer's contact information. So you're welcome to reach out to her about any content in the presentation. If you're having technical issues, you can reach out and by private chat to Dashiell Coleman. He has NCVC behind his name. You can send him a chat through Zoom and he can help you out with any of those. We are not doing attendance certificates or CEs for this webinar. If you do need live captioning, you can click the Show Captions button down at the very bottom. It should be on my screen, it's next to the Q&A, and that will turn on captions for your Zoom. And then if you have any questions throughout the session, we're going to hold about 10 to 15 minutes towards the end for those. Please make sure that you're putting all of those in the Q&A box and not the chat. We know folks love to engage in the chat, and we welcome that. But any pertinent questions that you have, please make sure those go in Q&A so we don't miss them. Next slide, please. So like I mentioned, this is, I believe, part 4 in our NTI webinar series. This is all about promoting NTI. I know many of you have come to our conference before. We always love to have you there. We're in Portland this year from September 18th through 20th. You can scan this QR code to find out anything and everything about the conference, our agenda, all of our sessions are on there, as well as the hotel information and anything else you need to know. We do provide CE credit for this conference. We are still in standard registration. That's going to run through August 13th. After that, the price goes up. So if you want to come, make sure you register now. And you can reach out to National Training Institute at victimsofcrime.org with any questions. Next slide. And our final installment in this webinar series is going to be Monday, August 19th at 2 p.m. Eastern Time. It's on supporting adolescent survivors of sexual violence, presented by Someplace Safe and Program Aid to Victims of Sexual Assault. And now I'll introduce Jennifer Waindle, Project Director from the Battered Women's Justice Project. We are so thrilled to have her and can't wait to hear her presentation. Turn it over to you, Jennifer.
Thank you, everyone. I'm going to switch between PowerPoints for a second. Like I said, it's those Wednesday technical difficulties. Bear with me. Here we go. All right. Thanks for bearing with me. And thank you for being here today. And thank you to NTI for inviting me to give this presentation today. I'm Jennifer Waindle, and I am a project director with the Battered Women's Justice Project, and I handle one of OVW's grants through BWJP, which is the Improving Community Supervision Response Grant. And so I help give technical assistance and training to anyone in the wheelhouse of MDT of probation, parole, and pretrial, and how that intersects in gender-based violence and sexual assault. I also assist our National Center for Firearms and Intimate Partner Relationships, where we have a firearm technical assistance project, as well as the National Resource Center on Domestic Violence and Firearms. Prior to joining BWJP 18 months ago, I was with DeKalb County, which is the second largest county in Georgia, and it shares the city of Atlanta with Fulton County. I began my career there in probation and parole for about 12 years, and I eventually led our domestic violence unit and developed a firearm relinquishment protocol without having any state laws that mirror federal law. So someone that's prohibited from possessing a weapon after a misdemeanor crime of domestic violence or under a protection order, we had none of those mirroring laws. So we had to figure out a different way to kind of go about disarming these defendants or probationers. And you'll learn a little bit more about that towards the end of this. After that, I switched into the investigations world, into the policing side of things. I wanted to see what cases looked like on the front end, and I was an investigator in our county attorney's office in our special victims unit first, investigating DV homicides, aggravated assaults, adult sexual assaults, things like that. And we eventually started a firearm violence prevention unit focusing on serial firearm offenders committing stranger aggravated assaults, drive-by shootings, but as well as focusing heavily on those family violence offenders with the family violence history that are still running around with firearms. And some federal partnerships I hope I will have enough time to tell you in the end. This is generally a 90-minute workshop. So I cut a wee bit more out of the probation section so that we can focus on those federal prohibitions and what they may be and what you might be able to mirror in your area to enforce federal law or state law under what you have. So we will go ahead and get started. This project is supported by my grant, and it's awarded by the Office of Violence Against Women. And I will say that my personal opinions, if I share those on here, are not those of OVW. OVW approves the slide deck and the content that I'm going to present to you today. But if I slip up and say a naughty word or something like that, for example, that's on me. That's not on OVW. Next, I have a disclaimer here because our state legislatures change their laws all of the time. The federal system does as well, but that's one system to keep up with versus 50 states and more. So if there are some notes in here, we'll say that I just changed one slide in here from 34 states have a misdemeanor crime of domestic violence statute that mirrors federal law. It just dropped to 32. So 2 state legislatures had gone back in and changed something in their code section. So there may be something I missed within the last 30 days, and I'm happy to address that if you slot that in the Q&A, or happy to follow up with you later if you know something that I don't. Always learning from everyone around here. All right, our overview today is part 1 are going to be some research statistics that we use to kind of focus on why firearms and firearms access in intimate partner relationships are a priority. We're going to discuss the national framework of things. I know that you all are joining me from all around the country. I would love to be able to tackle each state and each state's questions, but to keep it for simpler form today, we're going to talk about our national framework. We're going to discuss some evidence-based practices, and when we get to the end, I'm going to talk about what implementation looks like in the program that I developed. There are many other programs around the country that have done different versions of firearm relinquishment, whether it's around protection orders, either in the ex parte stage or the final stage, and how they recover those firearms or put the respondent on notice, the same as with the criminal legal system. So some might be probation driven, some might be the judicial branch or the court division driven sort of things. And I'll try and give you as many examples as time allows at the end for that. And research shows right off the bat that, the progressive 2-step approach is keeping things simple and making sure that you identify who the offenders are that you're trying to either disarm or prevent from having access to firearms in the future. We're going to order that surrender and what that looks like, whether it's an affidavit on the record in open court or signing a waiver or consult form, and ensuring the compliance. So we can tell them what to do, we can make them sign the documents, but what are we going to do for that accountability on the back end to ensure that compliance? And then the long-term goal is keeping the firearms out of the offender's hands long-term. We're going to talk about reporting responsibilities for background check databases. So whether you're an advocate on this call, a prosecutor, a law enforcement officer, probation officer, I will say that there are a lot of people that don't really understand or know what FBI NICS and ICS protocols are and what they're looking for when someone goes to try and buy a firearm from a federal licensed dealer. So we'll discuss that a little bit and make sure that someone is updating criminal histories or state histories so that our FBI partners know that if they're a prohibited person or not. And we'll discuss what expanding the list of individuals prohibited from purchases mean. So for now, a little bit about research. I will not bore you with statistics, I promise, for this whole workshop, but it kind of helps lay the groundwork and the foundation. And we like to use and rely as much as we can on insurance or CDC statistics, public health perspective, and staying away from some that might be, I guess, a little more hot topic. And one of those might be that Everytown. So we do use Everytown for gun safety statistics here and there, but we try to use insurance actuary, CDC, our Gun Violence Resource Center, Dr. Zioli, who I'll talk about from University of Michigan. So what we do know for homicides in which the victim and the offender relationship could be identified, so there was either the victim themselves that shared that, or the offender that disclosed it, or a family member, that 93% of female victims were murdered by a male they knew. So that doesn't necessarily mean that all of that 93% were their intimate partners, current or former. It could be a male that they knew that they did not want to have a relationship. It could be someone that was trying to pursue the victim for a dating relationship and they were declined, or it could be someone that had a stalking infatuation with our victim. As for the number or percentage of those that are intimate partners in the current form or in the past, that's 64%, which is a significant amount. So femicide is generally by a male and a male that they know in some form or fashion. Dating relationships account for half of these intimate partner homicides. And we're going to talk a little bit more about the Bipartisan Safer Communities Act that went into effect recently in the last couple of years to include dating relationships. Some of you may know it as the boyfriend loophole. We are calling it the dating prohibitor so that it's inclusive of all genders. Stalking has a huge indication for future homicide. I don't know about all of you out there, but whenever I have either worked with victims that were being stalked or was investigating stalking cases myself, they are hard to prove. And it's hard for some people that are not trained in our world of interest of what stalking looks like, or the having someone under surveillance and what surveillance looks like. So it could be something as overt as, peeking around the corner or popping out behind someone's car, or it could be something that seems a little minute when law enforcement arrive and you call to file a report for stalking. Real life examples were that I had two different victims with two different stories. One was that really loved tulips. And after she and her dating partner separated, he continued to stalk her. And he wouldn't leave a tulip on her car every day, but on occasion in different places, whether she was going out with her friends, she was going to work, or she was coming out to her car in the morning, even if she had parked 2 streets over, he would leave a tulip on her vehicle, just as like I know where you are, I know what's going on, and I want you to have me at the top of your mind. So when you call law enforcement and say, I'm being stalked and so is leaving flowers on my car, some officers may not know how to help them build that case for stalking. Another example, which is one that usually gets a laugh out of folks, is I had a victim that really loved Nutella, and this dating partner knew that. And so to get her attention, he was shipping by Amazon or, US Postal Service 1 jar of Nutella to her doorstep every day for somewhere between 30 or 40 days. And that case ended up escalating into a larger scenario of aggravated assault later. So stalking can look like many forms of things, but there is a direct linkage between stalking and intimate partner homicide or near fatal encounters. Strangulation as well. That's at our highest risk of future lethality. That's at 750% if there's a history of strangulation, that you're likely to be murdered the next time that occurs, where access to a firearm is super high at 5 times more likely, but strangulation's even higher. There's a really cool study that was discovered kind of by accident by the Riverside County District Attorney. and he works with the Strangulation Training Institute. And he discovered when they pulled a batch of 20 years of officer-involved shooting cases, whether the officers lived or not, whether the suspect lived or not, they noticed a well over 50% likelihood that those persons had a history of strangulation. So they're not only a threat to our victims, their family members, they're a threat to our responding law enforcement or our law enforcement that have encounters with them later. Firearms are generally the weapon of choice. As you can see in this chart, it's generally around 55%. That swings up and down a wee bit. And the next closest thing would be knives, bodily force, or blunt objects. But having access to a firearm or going to get access to a firearm, which is easy to do in our country, some states a little bit easier or harder than others, is probably why it's so prevalent. And that there's not a real understanding by sometimes our legislature that there is that direct linkage of if this person is terrorizing their own family, that they are more likely to kill them later or to kill those responding law enforcement officers or the mass shootings that we see in the community. It was 54% for a while. I think it might be a little bit higher now of our mass shootings in America stem from a domestic violence situation. So what people used to believe stayed in the home doesn't stay into the home. It spills out into our community and it's a threat to everyone. There's also the non-lethal use of firearms in coercive control. So in a Connecticut study, 25% of these DV survivors reported being threatened by a gun by their abuser. And that could look like a bunch of different ways. It could be literally presenting that firearm to the person. It could be pointing it at them, or it could be something where they leave it on the nightstand or at the foot of the bed or on the kitchen counter, so that the victim or the family members know that it's present, it's there, it's accessible, to put them at a higher alert of vigilance. It could also be something where the perpetrator is cleaning the firearm in front of the victim, or bragging about how often they go to shoot, or what a good shot they are, or racking their slide, or moving the rotator on a pistol. So it could look in a lot of different ways, but those are all different versions of using control as a future threat of violence. But what does all that mean? That means that, using these statistics, using, what you see in your community, whether it's an advocate, prosecutor, law enforcement, social worker, batterer intervention program trainer, that all of these things lead to, once we start seeing patterns for things become predictable. And when things become predictable, they can become preventable if we address them. So we're going to talk a bit about the law and the national legal framework. I'm a nerd about the law. I know that not everyone here is, but buckle up. We're going to learn some cool things today. So for our federal law addressing conviction of misdemeanor crimes of domestic violence, you might hear people call it shorthand of G9, but this 18 USC 922G code section, and there's G1 through somewhere in the teens, of different prohibitors for firearms access and who's prohibited or who isn't. So for example, G1, that I'm not going over today necessarily in a slide, is anyone that's convicted of a felony crime is prohibited from having a firearm in the future. Most people know that because each state has its own law to mirror that. So in Georgia, if I was investigating someone for a new crime where they used a firearm and they had a felony conviction, I would tack on the charge of possession of a firearm by a convicted felon. But I can't do that in Georgia for possession of a firearm after a crime of domestic violence. So to get back to it, 18 USC 922 G9 was effected in September 30th, 1996, and it goes retroactive. So if you had a domestic violence conviction in 1974, that would count the same. So it also is known shorthand as the Lautenberg Amendment, which makes it illegal for persons convicted of a misdemeanor crime of domestic violence to possess, ship, transport, or receive firearms and ammunition. So it could also be parts of a firearm. Under federal law, they could seek prosecution for, say that there's an officer on scene that has probable cause to believe, like maybe they find a scope to a rifle, but they don't find a rifle, and they uncover one round of ammunition. that one round of ammunition is a prohibition. They're not supposed to even have one round of, or bullet for some people, one round of ammunition or one bullet. It's a permanent ban on these things, and there's no official use exemption. And what that means is some people might say, well, I'm a police officer. I'm in the military. You can't take my firearms away because I need those things to do my job. Well, in the case of this, there's no official use exemption. So you're not allowed to have a firearm in your home, in your vehicle, on your person, just because you're in the military or a law enforcement officer. The one little caveat I'll say in that is some have remained on duty and they check a firearm out at work for their responsibilities at work and then check it back in at the end of the day. But someone has to make sure that that weapon is secured away from that person before they leave their base or their precinct. Continuing, you need to have certain elements for this qualifying misdemeanor crime of domestic violence. So the type of crime, the relationship requirements, and then a due process piece. So the force and intent has to be there. Under state, local, tribal, or federal law, it has to have an element of use or attempted use of physical force. That could be assault, battery, offensive touching, or threatened use of a deadly weapon. One of the examples that the Supreme Court gave, I believe it was in Castleman, and someone might catch me if I got that wrong with something else. But either way, there was an example in the testimony where if someone comes through a kitchen and their intent was to slam the door into the other person or forcefully move the person or strike the person without their consent, that counts as the use of physical force. And of course, it could escalate higher than that. So our relationship requirements that need to be there is it needs to be a current or former spouse, parent, or guardian of the victim, person with whom the victim shares a child in common, person who is cohabitating or has cohabitated with the victim as a spouse, parent, or guardian, or a person similarly situated to a spouse, parent, or guardian. And what guardian, not guardian. So what similarly situated means is that you're in what appears to be a committed relationship that would look like if you were to be married or if you were to have a child together. So you share the same residence. You may or may not share finances. You have a key to the home. You get mail there. Those are things that are similarly situated. And these were all requirements before June of 2020 for that bipartisan safer community. So the new federal relationship requirement that we added was dating partners. It also goes by the shorthand of BISCA, Bipartisan Safer Communities Act, and that was with the last VAWA reauthorization. It added a dating relationship, and state relationship laws might be a little more different. So you're going to want to go by what your own state is, but for it to be the federally recognized, it has to be one of those things I said before about similarly situated spouses or parents or guardians or those that share a child. But we're also going to add that it's a relationship between two individuals who have recently had a continuing serious relationship of a romantic or intimate nature. For it to be determined, things are length of relationship, the nature of the relationship, frequency or type of interaction. So it's something that's not casual. It's not a one-time date or a one-time, whether there's physical intimacy or not, one of those sort of things. It's an ongoing sort of relationship, and relationships mean by name all sorts of different things to different generations and different ages of things. And because it's newer, there has not been a lot of case law on arguments one way or another what a relationship qualified in the state of Texas as a dating relationship versus New York. So that will all be coming as time goes on. So the key differences between these convictions for domestic violence and dating violence is the date of the conviction and when is the firearm prohibition listed. So what I said earlier was that Lautenberg Amendment, so folks that were really in the longer term relationships, living together, cohabitating, sharing a child in common, they've either been married before, or currently married, things like that. That's the lifetime ban part. If it qualifies under this that you're seeing here, the dating relationship, the dating prohibitor, the boyfriend loophole, they are eligible to have their rights restored after 5 years, with the caveat that they do not get arrested for any other crime of violence, whether misdemeanor or felony. So they are eligible to get their rights back to have firearms unless they're convicted of a new crime. So we're going to talk about some of these evidence-based practices. And I only see one question down there, and if someone feels the need to interrupt me to ask it, that is fine. Just let me know to the rest of my panelists. So going back to the original slide that we had about our two-step approach. So there's going to be the removing the firearms from the offenders. And what do we need to do that? We need to identify who they are. Is it domestic violence restraining orders or protection orders? We're not going to get into the weeds on extreme risk protection orders, or ERPOs, which, by the way, BWJP has the National Center on Protection Orders in Full Faith and Credit. We have a whole team dedicated to domestic violence protection orders and extreme risk protection orders. So feel free to reach out to me afterwards, and I can connect you with that team if you want to discuss that at further length. And those that are convicted of misdemeanor crimes of domestic violence. Our second part is keeping those firearms away from offenders, making sure that we're adhering to what the law is, that they're adhering to it, improving our reporting practices, and expanding our list of individuals barred from owning weapons. And that could be, like I said in the beginning, on the issuance of the ex parte portion of the protection order, meaning that our petitioner or victim goes to court and fills out their affidavit that these things have been happening and they are at a threat of future risk of violence, and the judge issues the ex parte, meaning we're going to serve our respondent or our possible offender if there's criminal charges, and they're going to be served. And during this time period, someone could order that the firearms are to be removed at that point. It's more common for it to be removed after the final order. There could also be violent misdemeanors that aren't included state by state, that are in addition to our domestic violence. So it could be other violent battery misdemeanors of stranger violence. It just depends. You have to know your state's code section to figure out who can be added in addition to the federal prohibitions. Katie, did you have a question?
Yes, Jennifer, your one question so far is, what about friendships? How would that difference be classified legally? Or how is that difference classified legally?
Question, because some states have, we'll say, for example, roommates were in the code section in Georgia, still is. And the reason that roommates were written in there, which is further outside of that federal framework of relationships, was to cover same-sex relationships in the 90s and early 2000s before gay marriage was legalized. As for friendships, if they are not intimate in nature, those would not count as a prohibitor. And if you want to reach out to me for a video chat on discussing what friendships might be, if you're thinking it's a little bit different than what we might call a normal friendship that is not intimate in nature, I'm happy to have that discussion. Thanks for the question. So like I said a little bit earlier, some states might have a broader definition of what those qualifying relationships are. States may implement firearm restrictions that reach beyond our federal prohibitions. That happens too. Some don't have anything that mirrors, like I said earlier, so they're further back. And usually there's supposed to be a disclosure of states receiving the assistance of the federal partners are supposed to make sure that on the record, the person knows in their court proceeding that they are not allowed to have these firearms or ammunition or their carried concealed permit anymore. Ordering that firearm surrender. States have some sort of statutory provision for ordering a firearm surrender if there's already a law in the books about relinquishment. Some of these authorize law enforcement officers to seize them. Others require what I call the honesty method of the respondents to surrender those firearms. When these things happen, there's a reduction in intimate partner homicide by anywhere between 9 and 12%. And some people will say to me in workshops, well, I don't really statistically significant, 9 to 12%. And what I say back is, if you have a room of 100 survivors right in front of you right now, and we can take 9 to 12 of those folks, out of that block of people, that's 9 to 12 lives that we've saved potentially by doing this. And so 9 to 12 lives mean a lot to me. So that is statistically significant. When you're ordering that firearm surrender, let's talk a bit about what people's roles are. Frontline law enforcement's role, that varies from jurisdiction to jurisdiction, from state to state. So you may have some states that are very firearm friendly, where you can open carry everywhere and there's no concealed permit required. I live in one of those states. Some agencies in our more rural areas are nervous to ask questions of, if you have a firearm and you're carrying it concealed or open, are you a prohibited person? Do I have the right to ask you that? When do I have the right to ask you that? When do I have the right to run your NCIC during a traffic stop, and you have a firearm and you have committed a traffic infraction and it comes back and says this person has a conviction for family violence battery? What does frontline law enforcement do about that? What if it's 3 a.m. in the morning and they can't call ATF, the U.S. Attorney's Office, or the County Attorney's Office for guidance? It might be that frontline law enforcement needs to take that firearm for safekeeping. They're not permanently disarming that individual, but they can say, I'm not sure that if you're a person that's allowed to have this firearm, even though it wasn't used in the incident that we're talking about right now, I'm going to take this for safekeeping. It's going to be in our property, and you can come back tomorrow, show your proof that you own it, and then we'll run your criminal history as well as your protection order registry and just double check that you are not a prohibited person. What's the court's role? Is the judge saying or making it known on the record, or is it already on the disposition that under federal law, after X, Y, and Z conviction, you can't have these things anymore? And then what's the accountability for that? Are there going to be compliance hearings later, or are you going to rely on probation to do that, or the prosecutor's office to set that up? What's probation's role? Probation has the case generally longer than anyone else in the process. So you have, your uniform response. You might have your detective's response to a domestic violence scenario, and that could, and this is a broad range, but that could last from 30 minutes to 3 days. And then the case gets bound over to your county attorney's office, where hopefully an advocate's reaching out to the victim, and then they'll update them periodically over time about when the court hearings are. Your county attorney investigator is going to look at the case on the front end, see what evidence they may need, but they're not going to interview the perpetrator most likely unless there's a requirement for a new conversation with them. Then your prosecutor is going to have the last step of the case before it's presented to court for either a plea or a trial. Probation has long-term contact with that probationer afterwards. They have long-term contact if that relationship continues with the victim or the family. And they wear many hats: the social worker hat, the law enforcement hat. And so they are tasked with a lot in compliance. And sometimes they're not aware of everything they have to do because there's not a lot of information sharing between frontline law enforcement, prosecutor's office, and probation. It's better in some areas than others. And what's our defendant's role? That's sort of a trick question. Our defendant's role is that they know whether or not they're supposed to have these things. And they know whether or not they're breaking the law with that. If we'll say that there's a small percentage that say they didn't understand, it's our role throughout the system to make sure that they understand and that they're complying. So for violent misdemeanors, this is the one that just changed recently from 34 to 32. There's 32 states and our Washington District of Columbia that prohibit firearms for individuals convicted of either gun-related or violent misdemeanors. That's from our Gifford Center to Prevent Gun Violence. They're wonderful. You should check out more of their statistics. And Dr. Zeoli that I mentioned earlier, and our colleagues, but Zeoli, April Zeoli with the University of Michigan, she is right at the front of the line of doing long-term work of research on intimate partner violence and firearms, whether that's homicide, near homicide, or that coercive nature in the beginning. What it looks like when firearms are folded into the relationship in the beginning, the middle, and the end. And she found that such laws like these, regardless of the relationship between the offender and the victim, were estimated to reduce intimate partner homicide by almost 25%. So remember, I had that block of people in front of me, those 100 survivors. We took 9 to 12 out. Well, what if we could take up to 25 out? That's 25 people that possibly are lives that we could be saving. So that's an even higher statistical significance.
Jennifer, while you drink your water, I've got a couple more questions for you.
Okay.
So can you review the firearm ban and when it's lifted again? And does that only apply to misdemeanor convictions, or does that include felony convictions as well?
I was discussing mostly the misdemeanor convictions. The felony conviction is a lifetime ban. Let me go back. Sorry to do it quickly like that. Hopefully I won't make any of you dizzy. So this one, the Lautenberg Amendment. So conviction of a misdemeanor crime of domestic violence is a permanent lifetime ban from that retroactive. And that's where we had the element or attempted element, use of force, and then it's these qualifying relationships. And you're going to get these slides at the end. So just make a note that you need to go back and look at these, and these are the qualifying relationships. And the other part of the question, Katie, was maybe about the dating relationships. So those are the ones that can get the firearms back after 5 years if they don't incur a new criminal conviction, whether felony or misdemeanor battery conviction related. So, and that could be battery against a stranger or battery against an intimate partner. So they have to stay out of trouble for those 5 years.
Okay, great, thank you. And for frontline officers to seize a firearm without the ability to check if the person has a domestic violence conviction, what requirement / reasonable doubt is necessary to justify that? Have you seen the ability of officers to remove these firearms lead to more racial profiling?
I don't have the answer for you and the deep dive of statistics about racial profiling. I'm happy to converse with that person after this. But without being able to check someone's criminal history or protection order registry to see if they're a prohibited person, I don't think you'd have the safe probable cause there to take that firearm unless they disclose that, some people might say I was put on paper, I was on probation for this, and it was something with my girl or my guy or something like that. So if they give some sort of information or inkling to the officer, if there's not something that they can pull through a secured data system, that might be something that would give frontline law enforcement the ability to take that firearm for safekeeping to the next day. Hopefully that answers it. Okay, so now we're going to get to FBI NICS and universal background checks. So part of what I already mentioned earlier, NCIC, is that National Crime and Information Reporting System. So when someone gets first arrested, they are booked in, and what booked in consists of is taking a fingerprint card. That fingerprint card is then sent to that state top law enforcement agency, and it's also shared with the FBI. And this starts a tracking process, an offender-based tracking system. So from fingerprint all the way until the end of the case, it should be updated as things go. So say they get booked in initially and it's 1 count of family violence battery, but by the time it goes to court, they may add family violence battery, or if there was a child witness to the case, it might be a cruelty to children misdemeanor level, if they heard or saw something, and it might be a disorderly conduct. So it could be adding charges through that process. So someone goes in and updates that. At the end of the case, say it's dismissed or not presented to grand jury, not accused, or the person pleads guilty, someone goes back to update the system there. The big catch is that not every agency follows through with that, whether it's the clerk's office, the prosecutor's office, the probation department. It's different everywhere you are of who's responsible during which parts of the stage for the terminal agency coordinator to go in to make those updates. But people should be mindful of who their person is that does this, who their agency is that does this, and make sure, like, we'll say that the person is found guilty of family violence battery. It's helpful to have no contact with Jane Doe, attend a batterer's intervention program, do not return to 123 Maple Street. So that way, when an officer does key up, or I'm sorry, go up to their microphone to get information for dispatch to tell them what's going on, they can read that information to them. And then they say, oh, is Jane Smith here? Or we're at 123 Maple Street. That's an example of why those things are helpful. The other way that it's helpful is if I know as that law enforcement officer that night or the detective investigating the case later that this person already has a family violence conviction or a felony conviction or something like that, that I know that they can't have these things anymore. So that's the first part of the criminal history information system. And there's another part that happens where, say, either the person's on probation now or they've been indicted for the case and they're awaiting, final word on whether they're going to plea or have a trial, and they go out to try and buy a firearm. And that's to say that they don't private party buy it from someone. They buy it from a licensed dealer or pawn shop that's a dealer as well that runs their history. So they have to fill out the firearms form that every normal person has to go in. And you have to say, whether you've used substances, and so illegal substances or narcotics, if you have mental health condition, or it'll ask you if you're subject to a family violence protection order. Do you have a misdemeanor crime of domestic violence? Do you have a felony conviction? And if they answer no to those things, whether they answer no or yes, but they'll run that paperwork and it goes to FBI NICS. FBI NICS looks through it and they say, on criminal history there's a battery charge, but I don't know what happened to it. It's from 1998 and there's no update after they were booked in. So they will send an alert to the county of where the person tried to purchase the firearm, and they'll send an alert to the original county where the crime took place and where they were booked in. And you have 3 days of turnaround time. So they're going to say there's going to be a sheet, and it's on the front, it's going to have big FBI NICS. And it always comes by fax, which is, in my opinion, pretty old school, but they're required to do that. It's up to your agency to ask them to email you too, because sometimes things fall off fax machines or sometimes they end up in the shred pile. Someone has to be responsible for looking for these future information requests and following up and answering them. So what happens? That person goes to try and buy the gun. FBI NICS needs more information, so they send these notices. They send it to the clerk's office, to probation, to the prosecutor's office, and to the sheriff's department or whoever your top law enforcement agency is there. And they're going to say, please, we need this information with 3 days to know if this person can have that firearm sold to them or not. So what happened to this battery charge? Who's the victim? Was it domestic in nature? What was the adjudication? So was it dismissed? Did they plead to it? Is there a conviction somewhere? So someone has to follow that down and send that information back to FBI. And then they'll determine whether to deny the sale or not. So what happens if we don't do that? If we don't do that, they don't have the ability to restrict the sale. So if that prohibited person goes back on the 4th day and they're like, hey, have you heard anything? I still want to buy this Glock. And the licensed dealer has at that point the decision to make. They can either deny the sale and say, I don't feel really good about it because they never told me that you were okay. Or they could say, yep, let's go ahead and finish the sale out now. And what happens is 2 or 3 weeks later, if someone finds that fax that's on the floor, or it ends up in someone else's file, and they look at it and they're like, holy smokes, this person's been convicted of X, Y, and Z. And then they send that information to the FBI. The FBI then has to reach out to the U.S. Attorney's Office and to the ATF to see if anyone's available to go take that firearm away from the person. And that depends based on man and woman power around the country. So these things are super important. Hopefully you'll learn a lot today, but if nothing else, go back to your agencies and figure out who's responsible for these FBI NICS requests. So we're going to talk a bit about implementation now, and we'll get into the program that I developed. And let's get this one. So firearm-surrender. We're going to look at probation's responsibility. For my POs that are on this call now or that will be watching this in the future, figure out who on your caseload qualifies. I was lucky that I came up in an agency that had a dedicated high-risk domestic violence unit. There are 57 or 59, I think 159 counties in Georgia. It's a lot, right? And only 3 had dedicated domestic violence units. The rest, it was all folded in with a lot of other cases. And that's not that uncommon. And there's a lot of reasons for that that I don't have time to get into today. So we'll say that if you don't have a dedicated caseload, if you've got entering autos or burglaries, but you also have this, domestic violence, battery or strangulation or something in there, you need to identify who on your caseload qualifies. Do they own firearms now? Do they own them in the past? And you get those answers by either asking them or people within the home or pulling old police reports, looking at criminal histories to see if they have 8 or 9 carrying concealed weapons charges. That's a clue usually. Will the defendant live in a home with firearms? So when they get out on parole or probation and they go and live with grandparents or parents or best friend or new girlfriend, old girlfriend, are there firearms in the home? If there are, they can't be there. They can't be in the car when they're riding around either. And it's not the responsibility of the person that they live with to have to get rid of it unless that person continues to stay there. And then figuring out what compliance and surrender looks like in your jurisdiction. So some probation agencies are sworn, meaning that they are peace officers with powers of arrest. That was the type of agency I worked for. That's not everywhere. That's not in every state. That's not in every county. So when those case officers go and do field visits, are they going with the sheriff's department? Or do they do fortress style probation where the probationer always comes to them? What does follow through or accountability look like to make sure that these people don't have access to firearms if you're not checking behind them? So our supervision rules and kind of what helped me work my protocol was that the number one rule of everyone on probation or parole is to not violate any law of any governmental unit. That could be city code, county code, state code, federal law. So even though I didn't have Lautenberg Amendment, when I had probationers running around either committing new crimes with firearms or terrorizing their victims by firing rounds in the ground outside of their house or into their house, or just carrying around firearm in open plain view. Since I didn't have that state law, I knew that that number one rule is you couldn't violate that federal law. And that helped me start the conversations with our bench on what to do about what compliance could look like for us disarming them. You want to ask about firearms immediately at that first intake at court, again when you do your first office intake, your first release meeting, and almost every single check-in that you come in. So are you going to your batterers intervention program? Tell me about that. What are you learning? Have you been going to your substance use disorder classes? Kind of where are you in your program? Are you going to AANA, or do you just choose to keep going with your counselor? You still are aware that you're not supposed to have any access to firearms or ammunition. Are you around any of that? Are you living with anyone? Is there one in the car that you rode with today? Keeping those conversations going so that they know that you're looking for that. And then develop a protocol that works for your area for compliance, ensure safe relinquishment. So some people do not have the ability to collect the firearms themselves, but your sheriff's office might, your local law enforcement office might. If you're a probation agency that has an evidence or armory, we were able to take it. But not everyone has that ability or privilege. Same, like there was a judge in Dallas, Texas, Judge Kanyes, I believe he's retired now. His workaround was that he had a partnership with a licensed firearm dealer where his respondents in family court and protection orders, as well as the misdemeanor crimes of domestic violence, could turn this firearm into the licensed dealer. And if they were eligible to get the firearm back after the protection order, if the person was on first offender, then they could go back to the gun dealer to get it back because they didn't have local law enforcement to have the ability to take it at that time. So there's a lot of different ways to look at it. And that's what I'm here for later, long term, if you want to discuss what that looks like for your state or your county. And then what does accountability look like through sanctions or revocation? So if I do a home visit and I find that one round of ammunition, if there's not another case to go along with it, my federal partners in Georgia may not have anything to do with that. So I know under federal law, they're breaking the law and they've got this thing, this one bullet or one round of ammunition, but there may not be anything I can do other than bring the person back to court for a sanction or revocation, let the court determine that. So our first attempt was in 2006 to 2007, and this was not my idea in the beginning. It was actually the idea of a victim advocate named Betsy Ramsey, who retired around 2012. And she wanted to make sure that every defendant was put on notice that they couldn't have these things anymore. And we had a group of folks together. We had our bench, both our prosecutor's office, because we have a district attorney and a solicitor general, our magistrate court, superior court bench, state court bench, and probation involved. And I remember I was a baby PO is what I call it. So I was only a couple years in, but I was in the domestic violence unit, sitting around all these folks, and we're talking about whether to put this one line on a disposition or make it a probation protocol and things like that. And it didn't go anywhere. Our bench at the time was nervous that we were wading into federal territory when they were a state court or a state superior court, and it just kind of fizzled. When Betsy Ramsey, went to retire around 2012, I asked her if I could take the work that she had been doing and continue on with it. I had some really scary cases as a probation officer of defendants going out and committing new crimes of firearms with violence, whether towards their victims or the community. And I was personally very frustrated that there was not a way to hold them accountable during those revocation hearings at a time when, say, they were arrested for a new charge of aggravated assault or burglary or home invasion or something like that while it was still pending and the person had bombed out. Sometimes our judges absolutely would not want to rule on that until it went through its process. Whereas if a firearm was recovered and recovered on that person, that is something that I could address in our revocation hearings, but not at the time. So I partnered with Jenny Stolarski, who was our chief assistant in the Solicitor General's office at the time, and said, I want to figure out how we do this. And from a prosecution and probation perspective, let's put this back together. Let's figure out what a protocol form might look like. Let's figure out what a probation-driven program would look like so that it takes some of the burden or the responsibility off the court, and hope that our judges will listen this time. Our bench had changed a little bit. Our task force was kind of going through a dormant period at the moment. So it was really just the two of us, and then my chief, and then her elected. So we met with our clerk of state court, who ended up becoming a really great hidden ally. She was someone that we all very trusted, very smart, and the judges listened to her. And when we pitched the idea that we wanted to put every probationer that's convicted of domestic violence on notice, she was like, absolutely, of course. And this could save lives. Let's do it. I'll help you talk to the bench. And so she did. And she helped facilitate that conversation where it was a non-starter before. She really helped us get the momentum with our judges. Our advocates were on board. Everything was good. We were actually really worried that it was going to be a huge uphill fight to get our bench on board. And it wasn't. That was our hidden ally, was our state court clerk that we just didn't know. So you don't know who your hidden ally might be hiding there. So our first goal was not even to take the firearms. It was just to put the defendant on notice. So I wanted, and I'll give you, at the end, you're going to get these slides and my protocol form that you can doctor up any way you want. And then you're going to see a little bit of the form in the next slide or two. But I wanted to put them on notice. So I want to give them the lengthy, scary paragraph about, the 10 years in custody and the multiple $1,000 fines and federal law that you'd be violating if you have these things anymore. And then squeeze a little bit of a state law on there as well, of something that might have covered them for, at the time, carrying a concealed weapon. And then I wanted to ask them, do you have any firearms? And they needed to initial, yes or no, like I have them right now and these are what they are, or no, I've never owned these things ever in my life. Or number 3, which was, yeah, I had one 6 months ago and then I gave it to someone else, or I gave it to my uncle, or I sold it. Great. I need to know what happened to that so we can track that down. And then our second goal was going to be collect the firearms and ammunition if we could. But at least with that affidavit document that became the protocol through probation, our judges would recognize that when the revocations came later, that they were put on notice at court, again at probation, and then they violated when they were caught with a firearm later. So in order to collect the firearm and ammunition, because I did cold calling around with law enforcement agencies in my county, and they said they did not have the storage space or ability to take those things at the time. And that conversation has since changed once our our local law enforcement partners and I saw what little time it took each month. It does not require an additional staff person. It requires maybe 2 or 3 hours extra per month in duties that you're already doing to take those firearms or release those firearms to people that are allowed to get them back. The other hidden secret is that a lot of this is honor system based. So when you're going to someone's home, if you don't have the probable cause to search it or a Fourth Amendment waiver, and you're asking the person to, turn in this firearm or give them the ability to turn it in safely to the courthouse or the sheriff's department or something like that, and they don't do it because they say, "Oh, I don't have those things. Never had them." A lot of it is honor system based, and then you're using that form later to enforce. So we never collected hundreds and hundreds and hundreds of firearms like we were worried. We thought it'd be this, deluge of lots of firearms. And most places around the country that I've spoken with, when they first started, it was not tons and tons of firearms. A quick case example, because I know we're running out of time. We started a little bit late, but I just wanted to say, this case example, he was the first successful revocation under our 2014 protocol. He was a domestic violence offender, and he had violated his probation by committing a new crime of domestic violence against his wife. And it was so bad, and she was so scared that she drove 3 counties away for medical treatment. Law enforcement did a report. We get to a revocation hearing, and at the time there was marital privilege in play, and she invoked that, and he walked out, revoked, time served, reinstate, sort of thing. And I kind of kept my eye on him, like most POs do with troublesome probationers. And he was a music artist, and he posted a music video where he's shooting an AR style rifle several different times, had several different rounds of ammunition. There was also use of narcotics or veiled use of narcotics on the video. And we had to figure out when that video was made, what range it was shot at, because he shot it at a firing range. So I was watching this video over and over, and there's several firing ranges in the metro Atlanta area, as you can expect. And so I figured out which one, and then we teamed up with the prosecutor's office and went down and interviewed the range master, able to determine when the probationer was there. It was after his conviction period. Copy of his ID, how many rounds of ammunition he purchased, and that he had brought in that AR style rifle himself. And fast forward, a warrant was issued, and we ended up revoking his probation for the rest of its term based on having that protocol in place and him having the firearms and purchasing ammunition. And that was within probation. And this is the form. You're going to get it at the end, so I'll squeeze through pretty quick. And then just as a quick highlight, in DeKalb County, we have kind of a total systems package. You have probation that you just heard about. We have a strong prosecution partnership with our federal partners of ATF and U.S. Attorney's Office of identifying cases on the state level that the federal liaisons may be interested in prosecuting. So someone with a 10-year egregious domestic violence history, and they're still running around with a firearm later, they may be interested in that. Can give you advice on that later as well. Great communication with our county police and our sheriff's department. Our sheriff's department takes the firearms for our magistrate court respondents, and that also goes through the protection order. So in summary, you need to fit a goal for your jurisdiction, start your conversations about the topic, whether it's an elevator pitch, and figure out who your partner is, one or more leaders, your squeaky wheel that's kind of keep this going. Brainstorm with your task force, look for your hidden allies, use statistics. Don't use as many as I did in the beginning, but use 2 or 3 that are really good. Keep it simple and be persistent. This is me. And thank you for letting me be here. I know I ran a little bit long. As you can see, I'm really passionate about the topic. It's hard to squeeze it in.
Thank you so much, Jennifer. I feel like there's so much great information here. So I'm grateful that you have offered to connect with all of our attendees today, because I am sure that you are going to get some questions. We have 2 questions. Feel free to stay on for a couple minutes if you want to. We'll just do those really quickly. And then, like I said, Jennifer's contact information is on the screen, and it'll also be sent out later on. So the first question, Jennifer, is, do these laws apply to protective orders as well?
I did not go over that because the probation part that I was trying to focus on, like I said, there's a lot of information. I didn't get into the national slide on that, but yes. So if someone is under a family violence protection order, for the term of the protection order, they are not allowed to have a firearm or ammunition. And then that would be, remember when I said there's that 922G? G9 was the misdemeanor conviction. G8, which is also a little famous lately from the Rahimi decision just about a month ago, RHIMI from the Supreme Court, that was upheld. So that is still in effect.
Great. And then if the firearm is restored after the 5 years and then the person commits a crime, is there a more serious time penalty for having their firearm confiscated?
Currently on the federal level, there's a matrices of how they recommend what sentencing is, but I believe that it would be elevated. I can't give you a time or tell you what that would be, but yes, there would be an indication of future risk.
Great. Thank you so much, Jennifer. We so appreciate you. Like I said, this has been, I feel like my brain is just full of information. This has been so
It's a lot.
incredibly, yes, dense and helpful, and wonderful information. Thank you all for attending. We hope that we get to see you in Portland in a couple months. And you should expect to see a recording, the slides, and some additional information come out within the next week or so. Thanks so much, everyone. Have a great day.
Bye.